Hello, Kabir. How are you? This is Fabio Núñez del Prado and Hugo Forno from ICC Peru.
Pleasure to meet you both, gentlemen.
Thank you so much, Kabir, for agreeing to participate in this interview for ICC. It's a pleasure to have you with us. Thanks very much. So now we'll ask you some questions. Hugo and I will take turns asking questions, and we'll start asking the first question. Please, Hugo, go ahead.
Thank you so much, Kabir. Thank you, Fabio, for the introduction. So the first question we have is, what was it about arbitration that seduced you to be involved from the get-go, from the beginning?
Thank you, Hugo. I'm delighted to be here. So let me just thank you both and to ICC Peru for this awesome opportunity. I grew up in the Middle East. My family is of Indian origin. I studied in the UK, in the Netherlands, and then in the United States, where I currently live. I love to travel. I love to eat different foreign foods. I love things that are international.
Right.
And so when I was growing up, I didn't know exactly what I wanted to do, but I wanted to have a career that had an international component in it. That I was clear about. Now, while I was in law school, like a lot of us, I got very interested in public international law, in human rights, and I really thought that I was going to become a public international human rights lawyer. That's what I kind of studied at Oxford, at NYU. We graduate in the US in May. It was in April, so a month before graduation, that the reality of visas, the reality that you need to have a steady job with a steady paycheck hit me. And I went knocking on a professor's door at NYU. And this professor, the late Professor Tom Frank, just an incredible mentor, recommended, Kabir, why don't you do arbitration? And it was an area I had studied, but never really thought about. But this is when you have wonderful mentors who can change your life. He picked the phone up and called one of his former students, who happened to be the chairman of the firm in which I got my first job. And I'd like to tell you it was Kabir who was this amazing lawyer, but it was really the mentor who played his magic. And the rest, as they say, is history. So with that, I'll pass the mic back.
Thank you so much.
Thank
for your
you so
answer.
much. Yeah, amazing. And the next question we have is, what is the trait or the virtue maybe that you most admire in an arbitrator?
Fabio, this is a very tough question. Even though the question, right, sounds innocent, I think there's something very deep here. Because, of course, we admire the ability of an individual to look at very complicated facts, look at very sophisticated arguments by counsel, and to take all these facts, to take all these arguments and come to a reasoned, well-informed decision. There is something beautiful in getting a person with subject matter expertise coming at a good decision. For me, what I think is special in arbitration is we are in many senses a community. Most of us know each other. I think the ability that despite us having close and personal relationships, yet to be passionate advocates and for arbitrators to be neutral decision makers, putting aside these personal relationships, these personal interactions that you may have, and coming up with something that can stand the scrutiny of an impartial observer, I think is really edifying. I don't know how to describe that better, but I think this ability we can fight as councils very passionately, but then go for a cerveza after it, right? So while you're with an arbitrator in council, I think interactions are restricted. But once a case ends and you meet at a conference to be cordial, but yet professional, I think makes it a very special, unique aspect of our
Absolutely. Absolutely. Thank you. Thank you very much.
So now we're going to go to the subject of, the hot topics, as we usually call them. So the first question we have regarding that is, what do you think are the most important effects that COVID has had on the development of arbitration?
Sure. This is a great question, because look, we should begin by acknowledging all of us as lawyers are on the privileged end of the spectrum. And many people, many businesses have suffered, and many have suffered irreparably, in an irreparable form. So we shouldn't lose sight of how privileged we have been in our respective jurisdictions. But despite all this suffering, one good thing that has come up, and I think this is really something we should be happy about, is the fact that we're doing things virtually. Now, virtual technology has existed, but we were reluctant to utilize it. I mean, what we are doing right now, we're in different jurisdictions, but we're able to connect, we're able to talk, which is beautiful. It's bringing us closer, it's bringing us together. From an arbitration perspective, right? One of our goals is always, how do we make things more efficient?
Right.
The techniques had existed. We needed a major calamity to force us to really utilize it. And the more we get away from COVID, I think we shouldn't lose sight of some of these advantages, some of these things that bring us together, that can help. We don't need to have 20 people in a hearing, have the 10 necessary people, but do we really need everybody in the room? So I just put that broad thought out there, and I'll stop with that.
No, thanks so much. Absolutely. And let me tell you, Kabir, that you made an amazing presentation in Lima. A lot of people have been talking about it. And I know that you talked a little bit about Chat GPT. So the next question, hot topic also, is what role, from your perspective, will Chat GPT play in the development of arbitration?
Fabio, this is really asking me to get out like the mystery ball and look in it and predict the future. So let me give a couple of reactions to that question. See, point number one, today, at this given moment, May 29th, 2024, ChatGPT is still in its relevant infancy. It's still a very new technology, and a technology with a lot of promise, but still in its infancy. So at this given moment, I don't think we have to worry too much about ChatGPT. ChatGPT at this stage, and I would encourage you all to do this, just go there and put in your own names. And I did this a little while ago, just to humor myself. Who is Kabir Duggal? I put that in. Okay. Now, ChatGPT apparently knows Kabir was born in the Middle East, is of Indian origin, studied in the US, the UK, and the Netherlands. It has this bits of information. It takes this information and makes stuff up. It literally makes stuff up, because I asked ChatGPT, where did Kabir study? And it just started giving me every Ivy League's name. Kabir studied at Brown, Kabir studied at Dartmouth, Kabir. So I think The first point I would just point out is at this given moment, ChatGPT is still, as they say, a generative AI is still learning.
Right.
A stage will come when ChatGPT will become very smart, very knowledgeable, and
Mhm.
it is going to change our profession in ways that we cannot envision. Two examples come to my mind. There used to be a time when people typed everything. So people who had typing skills, your legal assistants learned typing. They went to paralegal school and learned shorthand. With the advent
Mhm.
of computer, that changed. And the way we draft has changed, right? When you typed, you need to know your full sentence because it was typed and you had very little abilities to edit things. Now
Right.
most of us are drafting and editing as we are drafting. Uh, ChatGPT is going to do something like that. It is going to be horse carriages getting replaced with cars. We're fundamentally our profession is going to change. Uh, it is a little nerve wracking because, as lawyers, and more generally as people, we do not like very drastic change. But it is an exciting moment too, right? We don't know what is going to happen. It's a little bit of fear of the unknown, but an exciting moment. And like anything in life, we need to embrace it. One final
Absolutely.
point, and I'll pass it back to you. The Silicon Valley Arbitration and Mediation Center has given us a very helpful guideline document. And I encourage everybody, it's available on Professor Google, so just download the document. One of the core points they tell us in that document is that in arbitration, arbitrators should not assign core decision making functions to AI. That should
Mhm.
be an arbitrator's prerogative. So maybe you can use ChatGPT to summarize documents, to help draft procedural history, all the boring parts of the award that are necessary. Maybe things like that we can try to incorporate, but we still don't know. Great moment to be alive. And I pass
Mhm.
it back to you with this.
Thank you. Thank you so much.
Okay, so now we're gonna move away from technology. We've talked about technology regarding virtual hearings. Now, ChatGPT. This is a question that has been discussed. Uh, uh, it seems like forever. It's about the publication of international awards. We know that in investment arbitration, we
Yeah.
do have most of the awards published with the authorization of the parties. But what about the publication of international awards in commercial arbitration? Do you see that becoming a trend in the future?
Ah, Hugo, again, this is one of those questions where I have very mixed feelings, and I don't know how I exactly feel about the issue. See, on the one hand, there is such a push for transparency. More, more, more. We need to know more. Give us more information. Who are the parties? What is the applicable law? What is the seat? Who are the arbitrators? Institutions are feeling the pressure. All these platforms are coming up that are making information accessible. You're getting court awards, everything being linked. AI is playing a role in facilitating connections and making all these dots getting connected. So we are seeing that push, and we are seeing that push heavily. On the other hand, I see a tension with our fundamental bedrock principle of our arbitration, which is supposed to be confidentiality. We're somehow letting go of that bedrock principle. And I'm not sure whether getting all this information is necessarily helping the arbitral process in ways we think it is. It seems to me we're inadvertently changing our system into a semi common law system which is not what our practice was ever intended to be. Now, what is the research that we ask a junior associate to do? Oh, this is the issue. Go on these databases, find a similar case, and then we're going to make parallel comparisons. That's what we do in the common law. Most of the world was not supposed to be the common law. Arbitration rules tell us that cases are not supposed to be binding. So I feel this confidentiality erosion, this common law nature of doing arbitration, not necessarily as, and I say this as, for the most part, a heavily common lawyer, I don't see these as virtues. I see these as eroding something fundamental in how we had conceptualized arbitration. And I don't know whether more is always better. So I don't have a good answer, except I see these two competing values on confidentiality versus transparency kind of in friction and kind of in conflict with one another.
Absolutely. Very, very interesting. And the next two questions are related to your experience, actually. And since you have tons of experience, the question is, what good practices have you seen, witnessed in hearings that you would recommend incorporating in arbitrations that are not usually used in arbitrations?
Fabio, do you want to ask me the second question? Maybe I can combine both of these and answers, because I think sometimes the related question with this question may be a little easier.
Absolutely, I think they could be merged. So Hugo, please ask Kabir, please, the next question, so maybe he can.
I can combine. Maybe that's
combine them.
Another way to do them. These two.
Yeah,
absolutely.
It makes sense because it's the other side. The other question is, what bad arbitration practices, quite widespread, would you recommend eliminating? So quite the opposite of the first one.
Claro. So I do think our practice, for better or worse, has become very common law-like. And I don't necessarily see that as a good thing. The common lawyers are convinced that more discovery, more document production is a good thing. But that, we're often exchanging these 80, 90-page Redfern schedules where you're making very, you often do find things in documents, but the core issue is breach of contract, and here we are arguing upon, very peripheral issues, hundreds of dollars in a multi-billion-dollar dispute. And it's, why are we doing that? We're losing the broader goals and efficiency. For me, we need to curtail this. Now, for better or worse, even civil lawyers have embraced the common law notion on Redfern schedules. And just a related point, putting multiple witness statements that are often highly repetitive. You call them for cross-examination. It's all very sneaky lawyering in the way you phrase the question. You're never trying to get to the truth, the civilian inquisitorial approach, where the arbitrator will step in and really assume none of that is happening. And I do see that as detrimental to arbitration. We're skewing the system towards one system of law, which is taking away from how our international practice should be international. It shouldn't be the Anglo-American way of doing things. It should be the international way of doing things. But also, where is the efficiency? Where is the cost? So I think getting practices that can try to help us go back to basic first principles. Let's get costs down, let's get time down, and let's be efficient would be, in my view, the way to go. So virtual hearings, hybrid hearings, all of these techniques can help us. Having arbitrators that, I want to use the words have balls, but I don't think that's polite. But let's just use that word, who really control parties, rein them in, really this due process paranoia, which when I sit as an arbitrator is real. You don't want to give an appearance of bias. But at the same time, you're allowing parties to dictate the process. A judge would never allow that. And how is that efficient? For every silly issue, let's hear you now, let's hear you. And then the other party says, I want a rebuttal. Okay, let's hear you. Versus, you can on its face figure out that this has no merit. So having a little more control over the process, I think, would be another good advisable thing. The Prague rules in arbitration, which was actually a civil law response to the common law, IBA, soft law instruments, came out, I think, out of this genuine concern that our practice has gone to an extreme, to an extreme end, and we need to bring it back somewhere in between. Now, I think the Prague rules itself took a very extreme position, and extremes in life are generally not a good thing, Take the middle path, and that's the path of least resistance.
Absolutely. No, very, very, very fascinating stuff. Let's talk now a little bit about Latin America. So the next question is, from your perspective, in your view, what is the situation of arbitration in Latin America? What problems do you perceive, and what awaits Latin America in the medium and long term?
So, Fabio, this is a great question, because I think when we're in the Americas, Latin America obviously becomes one of the most important regions for us to be concerned about, for us to think about. I do think on the whole, it's a very promising, a very entrepreneurial market. So we see very committed, very knowledgeable, very passionate advocates for arbitration in virtually every Latin American country. And that's a good thing. You look at law schools in the US, because of our proximity to Latin America, our biggest constituents often in the arbitration classes are from Latin America. So I do think there is a very vibrant community. I think the two challenges we face. Challenge number one, I think, is, Latin America does tend to oscillate politically between one end of the political spectrum to the other end. Right. That seems pretty consistent across most countries in Latin America. That tends to give rise to investment disputes, right?
Yeah.
Very radical changes in political structures. And that is, I think, something where Latin America has often been disproportionately represented in exit and non-exit investment disputes. So that's one challenge. I think the second challenge is, we have a very vibrant arbitral community. The judiciary, like the judiciary in most developing countries, sometimes take very nationalistic decisions. And nationalistic decisions can be anti-arbitration. So I think, education for judges or education for members generally in politics and policy making capacities may be a bit necessary to try and ensure that at least when you're making a decision, you know what the potential consequences might be. So you may still take the decision, but at least you know what, often the politicians tell us, oh, we didn't know. Then they can't tell us they didn't know. I just want to know from both of you, as proud members of the Latin American arbitration bar, do you agree with how I look at? I am probably more optimistic, but I do think, looking at the knowledge and talent, that things are only going to go up.
I completely agree, but please go ahead, Hugo. And
Yeah, well, I think you're completely right with the well, with in both of your of the things you've mentioned. Um, Sadly, in the first one, I'm not as hopeful. I don't see uh, uh, a way out of this constant change between two extremes.
Yeah.
It seems to be the trend, not only in Latin America. It
No,
was the
correct.
trend in Latin America. Now it seems to be the trend all over the world. So instead of being hopeful for Latin America, I'm less hopeful
For the world at
for the
large.
world. Yeah.
Yeah. Very
Uh,
true. Very true.
and of course, I'm being like what I'm saying is based mostly on my experience in Peru, which currently I don't see a great scenario politics wise.
Mm.
However, I do feel, and this is mostly based in my experience with the judiciary in Peru, I do feel that uh, arbitration is such an important part of our legal system and of our judiciary system that judges just at some point had to get in with the trend. You know, so they have been trying to learn more and more, and I, from my experience now, first they're eager to learn, and second, uh, they do try to not they try not to interfere with arbitration. So on that side, I'm very hopeful. I think it's gonna be it's gonna keep on improving, and because arbitration, as I said, is a huge part of Peru's legal system now.
Right. Fantastic. That's
No,
fascinating.
yes. I can only agree with Hugo very quickly. It's part of our legal system, and I think that all the legal actors are learning about this arbitration environment, and this is basically what happened in Spain, for example, in which at the beginning it was very complicated for judges to understand that actually arbitration was not only a substitute of the judiciary, but it was a complement, you know. So it was important that they know about these international standards, practice, etc., etc. And now they understand it very well. For example, in the setting aside of arbitral awards, they understand what is the role. That is something that is happening also in Peru. So yeah, I'm a little bit hopeful. But yeah, politically wise, I'm not that hopeful. Regretfully, but
Upcoming elections in the US, I don't think I'm very optimistic about the political situation here too. And I just, on the point of judiciaries, it's very interesting because, I think if you look at US decisions from the 50s and 60s, they were pretty anti-arbitration. So I do think every country goes through its own moment of reckoning to come to terms with we're not competing, we're really, I think that complementary word was a very nice description. So
absolutely.
Great.
Well, in the topic of Latin America, and its problems, you know that a big one is corruption. So do you see that arbitration can be an effective mechanism to fight corruption?
Hugo, again, this is one of the very tough questions.
Yeah.
Corruption has been a global problem. I know some regions have faced it more than others. I'm reminded of this English High Court decision in the Nigeria versus PNID case, where Justice Knowles actually comes out very critical. And I encourage all arbitration practitioners to read this award. It's Nigeria versus PNID, where he really tells us arbitration, because in that case, a tribunal gives a $6 billion judgment, which becomes 11 billion with interest. That's like a third of Nigeria's finance budget. And underlying the whole case was this corruption that did not come out in the arbitration. It came out in the subsequent annulment and enforcement phases. And he took a pretty grim view about arbitrators trying to deal with these issues of corruption. Now, I think one practical problem that I think we can all agree is, the arbitrator doesn't have police powers. I can't go to Hugo's house and take documents. I can't take Fabio and throw Fabio in jail. I just can't do that, right? As an arbitrator, a judge can. So I think there are some practical limitations on what an arbitrator can do. An arbitrator can, however, ask questions and be satisfied that the answers the arbitrator is getting are good or bad. And to that extent, it can be, so to get back to your question, Hugo, can arbitration address corruption? It could, but arbitrators will need to work with courts, will need to work with counsel, will need to make sure that you're getting all the information to arrive at the right outcome. Otherwise, you will get a decision like we did in Nigeria, and that's not a good decision, right? I mean, I feel it really does suck when you see bad justice happening.
Yeah, absolutely. Yeah. And well, the last question is, what other hot topics do you see coming up in international arbitration? If you see any, please share them with us. We'll appreciate it.
Sure. I mean, I think, you really were very comprehensive, because I think one thing that comes to everybody's mind right now is artificial intelligence, and you already touched upon that. So I think I won't belabor that point. I think cybersecurity issues, that is going to remain a very important topic for all of us. How do you deal with hackings? How do you deal with hacked documents? Do we apply the fruit of the poisonous tree? All of those questions, I think, are going to be very significant, and we're going to have to come up with better law than we have right now on these topics. A related issue, just as a sociological matter, a few years ago, we were putting a lot of emphasis on diversity. And it tended to be largely focused because of the very poor representation of women on gender, and to a lesser extent on race. I think with the US Supreme Court decisions, everyone's a little scared about diversity these days. Now, I do think for us as a practice, which is international, we should not lose sight of diversity. Diversity still is an important goal. I just emphasize, we are talking in English, and most of the arbitration tends to happen in English, but we are in international practice. Why not Spanish when we have Spanish speakers? Why not Mandarin? We need to think of diversity broadly, and we need to make sure that we are welcoming for everybody. So I think cybersecurity and diversity, to be understood broadly, two good goals for us to think about.
Very wise. Very wise. Thank you so much.
Sure.
No, it was amazing, Kabir. Amazing. Thank you so much.
Thank you so much.
And I'll throw the ball to Hugo so he can give some closing remarks.
Well, nothing. I just have to, there's nothing left for me to say other than thank you so much for all your very knowledgeable answers to our questions. So I think in the end, what you gave us a promising view of arbitration in the years to come. That's a thing always nice to hear, and I really hope you're right. I know you'll be. So thank you so much for your answers and your time.
I was in Peru just last month, and I really had the best time. Not only do I think this country has amazing, friendly people, but I think the cuisine, the culture, the history. I had the pleasure to climb Machu Picchu 3 times. Really feel it is quite a
Three
quite
times.
yeah, exactly.
If one or twice wasn't enough.
One was just not enough, to be honest. It's been a
That's
real
great.
Thanks.
No, it was a pleasure. Thanks so much, Kabir. Thanks so much for your time, and we'll keep you posted as soon as we have the transcript and of course the interview. We will share all the materials with you. But we appreciate it very much.
Of course, I'm very easygoing. You don't need to. Y'all can send it to me if you want to, but I'm not going to edit anything. So of the firm view, once you say something, you should live by it. So.
Perfect.
That's great. Most people aren't like that, so that's very refreshing. Yeah, and this has been very fun. It's always great to talk to you.
Same here.
You always have a fun spin on things that aren't normally fun.
Well, I felt like it was friends talking, and that's always the fun kind of chats to have, right?
Yeah, it felt like that.
Yeah.
Well, thank you so much.
Oh, thank you so much. Take good care of yourself. Bye, Kabir.
Cheers.
Very nice to meet you.
Bye.
Bye.
That's it.